Here's a question for you. What's the difference between direction and discretion when it comes to paying out a pension scheme death benefit? The answer is probably 40% inheritance tax. Let me explain. If you're a member of a pension scheme when you die, the scheme administrator has to pay the death benefits to someone. The process of choosing the beneficiary or beneficiaries can either involve the scheme administrator using their discretion or you directing the choice before your death. The way the choice is made can affect the inheritance tax payable on the benefits. Let's consider direction first. And this is when you tell the scheme administrator exactly who should receive the death benefits from your pension. The scheme administrator will pay the death benefit in accordance with the instructions or your direction. The value of the death benefits will normally be counted as part of your estate for inheritance tax on your death. If the value of your estate is over the nil rate band of £325,000 or £500,000 including the residential nil rate band, if that applies to you, then inheritance tax will be payable at 40%. You can change your mind at any time before your death, of course, and ask the scheme administrators to pay the death benefits at their discretion instead of at your direction, simply by letting them know. This is normally done via an expression of wish form. The direction option is appealing for people who want to retain complete control and are not concerned about any inheritance tax liability. Bear in mind that the beneficiaries must accept the death benefits, even if they would rather they were paid to someone else for their own tax purposes, such as a child. If your nominated beneficiary dies before you do, your death benefits would still have to be paid to their estate and then be distributed to their beneficiaries. The other option is to use the discretion route, and this is probably what most people do. In a nutshell, you can allow the pension scheme administrator to use discretion when deciding who should receive your pension death benefits. You can still tell the scheme administrator before you die, of course, who you would like them to pay death benefits to, but the scheme administrator doesn't have to follow your wishes. What actually happens is that the scheme administrator or the trustees will review the most recent nomination but may choose not to follow your wishes if circumstances have changed. Examples of that would be if one or more of the people nominated are now also dead, or if you nominated your spouse but you've since divorced. They may decide it's no longer appropriate to pay the death benefits to your ex-spouse. Another example would be if there are more people to consider that aren't listed on your nomination, such as more children since you completed your expression of wish form. Bear in mind that the administrators or trustees have to be able to justify their decision in court if need be, so they don't take decisions to go against your wishes lightly. If death benefits are paid out in this way at the scheme's direct discretion, this usually means the value won't be counted as part of your estate, and so it won't be subject to inheritance tax. It's worth noting that once you've opted for the scheme to use discretion, you cannot change your mind and option for direction later on. So you might ask, in what circumstances might you choose discretion and what about direction? As ever, it's down to your personal objectives and what's important to you, but for the vast majority of people, the discretionary route works very well and avoids any possible inheritance tax liability. But if retaining control is of utmost importance to you, you may opt for the direction route. And as is so often the case, there's an exception to these pretty clear rules. If you transfer your pension from one scheme to another at a time when you know you're in ill health, HMRC may treat this as a transfer of value, and this means that your pension death benefits may be subject to inheritance tax, even if you opt for the scheme administrators to pay out your benefits at their discretion. You must survive for at least 2 years after the transfer to be sure that the usual treatment of discretionary death benefits will be applied, and they will be excluded from your estate for inheritance tax purposes. If you do die within the 2-year period, not only will the transfer of value be liable for inheritance tax, but the spouse exemption wouldn't apply. The spouse exemption is where there are no limits on the value of the estate that you can pass on tax-free to your spouse or civil partner. This means that inheritance tax could be payable even if death benefits were paid to your spouse. That's because the death benefits are being paid from a trust rather than from your estate to your spouse or civil partner. Somewhat bizarrely, the position reverses if direction is chosen in the receiving scheme. If you die within 2 years of the transfer of value would potentially be liable for inheritance tax, but the spouse exemption would apply. That's if payment was made to a spouse or a civil partner. On death after 2 years, the spouse exemption would still be available, but if discretion had been chosen, inheritance tax wouldn't normally apply at all. Thanks for checking out my YouTube channel. I'm Justin King. I'm a chartered and certified financial planner, and my aim is to help people live successful lives. And in my experience, that often involves understanding your money. I do hope you've enjoyed this video. If you have, please press the like button to help more people like you find my channel. For now, I'm Justin King, helping you live your best life.